Okay, it's not yet 6. Now it's 6. Okay, so good evening, everyone. So we will start with the presentations first. LT2 will present first, and then LT1, and then LT3, and then we'll proceed with our discussions on trademarks. Reg will set the timer, right, at 6 minutes. So you may begin. So if you are here, if you have a member here, I'd like to request that you present in front. If all of you are online, then you can stay in your seats and present online. Okay, thank you. Those online, can you hear me now? Yes. Okay. So
Yes.
if you weren't able to hear me, I just gave general instructions that will start with LT2 and then LT1 and then LT3. Reg will set the timer. And that's it. And then we'll proceed with the continue with the discussions on trademark. So if you have a member here, I'd like to request that you go in front. No, but if all of you in the LT are offline or online rather, then you can just present in your seats or in your from your locations. All right. Thank you.
Hello. Ayan. Okay, so good evening, classmates. Good evening, Professor. Learning Team 2 would present the intellectual property exercise for trademark search and application. So to start with, the team, or LT2, discussed how we formulated our chosen mark. So our analysis focused on coming up with the brand logo for the International Business Law Club of the Asian Institute of Management under the MIBL program. So this demographic is unique because it operates in an academic yet professional environment. It caters to students and stakeholders exposed to international law, trade, and cross-border transactions. And it engages in activities such as forums, publications, and institutional partnerships, which require a distinct and credible identity. So, given this profile, we recognize early that the club's logo and name are not merely symbolic, and they function as a brand that represents institutional credibility, intellectual authority, and continuity beyond individual members. So, this understanding justified the need to assess whether the proposed mark could be legally protected both globally and locally. So we implemented four steps in concept create. We implemented four steps. First, concept creation, global search through the WIPO, local application to the IPOFIL, and the final verdict. So next would be the difficulties that we encountered during the exercise. During the WIPO Global Brand Database trademark search, the opportunity we identified was to test whether our proposed logo could withstand global trademark scrutiny. Our initial design, Professor, generated 1,711,204 similarity hits worldwide, signaling that the mark, while conceptually strong, was too generic in global terms. So we responded strategically by revising the design 6 times while retaining the core concept. Subsequent versions showed a reduction in similarity hits, indicating improvement. However, the final version, despite being more visually complex and detailed, our sixth revision was more detailed than the first, generated 3.1 million hits, exceeding the even the original design. So this design, so that's I'm sorry, it's too small, Prof. But you can see, Prof, that
Can you show which one is your
design.
yeah.
It's in the next slide, Prof. Yeah, that one. So this revealed a crucial insight. Complexity does not equal distinctiveness. Adding elements may actually increase similarity if those elements are commonly used worldwide. So the difficulties we encountered during the IPOFIL framework trademark application. So this is from creativity going to the procedural process prof in the Philippines. So we then proceeded to the trademark application process to evaluate the local registrability. The challenge shifted from design to procedural and legal comprehension. So we encountered the following issues. First, the iPofil system is not user friendly. Well, as for me, because I did that, prof, and for my teammates as well, we actually asked each other about it, especially for the first time applicants. The language used is highly technical and legalistic, with limited layman explanations. We repeatedly encountered errors describing the club services under the NICE classification. And at the outset, we had no prior understanding of what the NICE classification is or was and how narrowly services must be identified. The explanatory notes for each class lack practical examples relevant to non-commercial or academic entities. And collectively, these challenges reveal that trademark registration is not a simple administrative task. It is a specialized legal process. So, based on our findings, we offer the following recommendations. First is to whether academic, nonprofit, or commercial should conduct a preliminary trademark search using tools like WIPO before finalizing a brand identity. Second, brand design should prioritize distinctiveness over complexity. A simpler but unique mark is legally stronger than a visually dense but generic one. Third, for the IPOFIL applications, we strongly recommend professional legal guidance, particularly in interpreting the NICE classification, drafting precise service descriptions, and avoiding procedural errors that delay or jeopardize the registration. Fourth, despite the difficulty in the process, trademark registration should be viewed as a long-term investment, not an optional step. The complexity of the system reflects the value of the rights being protected. And given the results should be pushed through with the application, so, yes, we would still push through with the trademark registration in the Philippines. The challenges we faced did not discourage us. Instead, it clarified why trademark protection is necessary. This exercise made us realize that branding intellectual property, trademark law from an entire ecosystem involving creativity and strategy and legal safeguards, it also demonstrated why this field is distinct industry within both business and the legal profession. Ultimately, the experience reinforced the importance of protecting creativity, institutional identity, and reputational value through formal legal mechanisms. In conclusion, this project transformed our understanding of trademarks from a design exercise into a risk management and legal strategy decision. By engaging with both WIPO and IPOFIL frameworks, we gain practical insights into how intellectual property operates in real life, globally, locally. Thank you.
All right. Aside from the niche classification, did you encounter any
Ay, nice
other?
pala yun.
That's okay. Any other difficulty?
Yep.
Any member of the group can answer.
Difficulty relating to the revision, prof, of the
Yes.
logo, because we realized that even though it had as we revised, we it had less hits, but we wanted to maintain the initial logo. And for example, it recognizes similarities in color. So if it has the same color, then it will have more hits. So we thought that we wanted to add more color, but as we added more details, it became farther to our initial the logo we initially wanted.
Yes, prof. I agree with Attorney Zenith.
When you say hits, what do you mean?
Um, yeah,
Sim
the similarity.
what you presume to be similar marks to the one that you registered or you tried to apply for.
Yes, Professor. And it is evident enough, Prof, that if we do not make our logo unique, for example, Prof, our the clients of the club may have in the future a visual challenge distinguishing the club from other similar brands that actually that is present in the hit list, prof.
Mhm.
Mm-mm.
And going back to the hits or to other potentially confusingly similar marks, were these marks local in the Philippines or did were they registrations in other jurisdictions?
Yes, prof. So there's a slide that we showed, prof, that
Maybe we can go back to the slide.
yes. This one, prof. So we have global hits, and then we also have the local hits here in the Philippines. Um, so as we tried to revise our design, prof, we thought our um we were improving based on the numbers that appear on the hit list. However, we were very surprised when we came up with the sixth revision that it was the most complex design that we had. We added a lot of features, um, and also, prof, a lot of different elements. But we were surprised that it generated the most hits globally. But locally, prof, in the Philippines, it generated only 32,000 as compared to the first design. Also, prof, in other jurisdictions, we've seen, especially, prof, in Southeast Asia, neighboring countries in Malaysia and Indonesia generated like almost the similar number of hits, prof, during the search. And also, prof, I think the number one, but it's not shown there. It's the US and China has the most number of hits also, prof.
Go to the next slide. I just want to see the. So this is from the
WIPO,
YPO
prof.
database.
Yes,
So
prof.
what you did was you uploaded the image.
Yes,
So
prof.
this is an advanced search, right? But the one that the slide previous to this, when you say hits, how did you come up with the numbers there?
There's a number generated up there, prof.
I see. So
Yes, prof.
that's the hits that you were
Yes,
referring
prof.
to. So
Yep.
everything that they posted
Yes, prof.
here. Okay.
They also, prof, can provide a generated report, but it's limited because of the immense number of hits. I think it's only up to a maximum of 180 logos that they could provide. The most similar to your logo that you uploaded.
So among these hits, did you find any logo that's really similar to what you envisioned?
Yes, Prof. But we have it included in the slide.
Mhm.
For example, Prof, there was one in China and also one in the US that really almost similar, Prof. I think the only difference was only the color. Mm. Also, Prof,
But the words international business lower there.
yes, Prof. Yes, Prof. That was included.
I see. All right. So this is the difficult thing about logos, right? When you upload a logo, it will show everything. That's why there are thousands of hits. And in fact, I'm not even sure if this database is able to show the most similar looking logo first before the least similar. So you could approach it differently to make sure that you're able to identify the most similar looking trademarks, right? And how do you think can you do that? Because what you did was you uploaded the logo. Another approach would be what?
I forgot the term, but there was wait, Prof, I'll check. There
Go
is
ahead,
something.
Janet.
Prof, there's a portion there wherein we could describe the logo, but because we tried that, prof, we just included ambigram, IBL, and then it also appeared. A lot of hits also appeared. We also tried describing using the colors, but then eventually, as we revised the logo, prof, we had a hard time describing everything because it we kept on adding elements, but using that description, prof, it provided lesser numbers compared to just uploading the logo.
Can I see the logo again? Does it also say international business law? It does.
It does,
At
Prof.
at the bottom, right? All right. Uh, so there are many ways. So when I conduct a trademark search, there are many ways to approach it, right? So you can what I would do is I would type the words first. So I would type IBL Club International Business Law and see what are the hits that I would get, right? And then after that, I would do an advanced search and I would upload the image because that's the only way to determine if there are similar images to the one that you are trying to apply for. Um, and then there are levels to it. I would examine whether or not there are similar registrations locally in the Philippines, and then I would try to examine if there are registrations abroad. And from there make an assessment. So I suppose no, the difficult um, uh, it's difficult no, to just assess based on the image,
Yes,
right?
Prof.
You will have to look at it from different perspectives. Sometimes you'll also have to do a Boolean search, right? So um, when you really want to make sure that your mark is not similar to anyone, you would do different iterations. So you can do IBL Club without a space in between. You would do International Business Law without spaces in between, because sometimes the system just does not is not able to catch any similar mark. No? So they're not able to get everything. Another option is to, or another advice is to use other platforms. So aside from the WIPO database, we have other platforms such as the Trademark ASEAN IP Register, which is also available for free. And so you can also look at that. There are many marks that are available in the database but not available in the register and vice versa. Right? So looking at more than one platform, whether it's a paid platform or one that's for free, would also be helpful in conducting a trademark search. Right? It's just advice, no? Moving forward if you're conducting a trademark search on your own for your businesses. Questions? Anyone from the other groups you may have for the group? All right, if there's none,
Thank
thank you.
you. Thank you,
And proceed.
Professor. Thank you, classmates.
Hello. Okay, thank you. So we'll have a walkthrough of our trademark search findings, the user experience most especially, and we'll speak from the lens of a business owner, a marketing slash branding consultant or manager, and of course the legal lens. We'll tap Attorney Dodi later for that. But before we dive in, let's hear a bit about the brands we'll cover from the proprietors themselves, G and Andre. Is Andre here? So we'll
Am
start
I,
with yes, we can hear you. Hey, Andre.
Hi, I'm a stone throw away. Nasa kanto na ako. Okay.
Oh, no
Sure.
worries. Take
Thank
care.
you. Thank
Safety
you.
first. So we'll start with Dream Shore. G, 30 seconds only, please.
It's just a simple wave that would represent different variety diversity of our local and international clients, leading to a goal which initially was represented by those stars, and it's called Dreamshore Global Business Services Visions Actualized.
Okay, so we'll hear more from Andre, our cohort mate who is licensed to touch. We'll hear more from him later. So let's dive in. Next slide, please. So for Dream Shore, we found 700,000 plus conceptual similarity hits. That's quite a lot. As you can see here, that's quite a lot. And who has time to review 5,000 plus pages? And the volume is really because the star as a symbol is commonly used across all industries. And the most prominent brand using both the stars, the 4-point star, and the wavy lines, as you saw earlier, is Philips. We're all familiar with the famous electronics brand. But are they confusingly similar with Dreamshore? No, clearly it's not. But we'll tackle the nitty-gritty later on. Before we move on, oh, there. So yeah, I was gonna ask if you see anything, if anything strikes you that we haven't mentioned. If not, we can move on. Okay, another prominent brand strongly associated with a star, in this case, the 5-point star, is Caltex. So this is how skewed the search results were. But will there be a high likelihood or a potential infringement in the future? Probably not. Very low risk. That's our assessment. But it's nice trivia. It's nice to know. And then we went beyond the WIPO search and actually also checked other active businesses operating under the name Dreamshore, probably without, well, for sure without a trademark because we didn't find them in our earlier search. So there's a resort in Kiwi using Dreamshore as the name. We saw a pillow brand sold in Amazon, a number of music related labels, and there's even an artist under the alias Dreamshore. They're not trademarked, but they are real active businesses. And then using the NIST classification, Dreamshore, or the logos actually, the elements of the logos are used broadly across all industries. And another brand that's closely associated with stars is of course Starbucks, but again, not confusingly similar to Giselle's logo. Okay, next. Overall, oh, there's one hit on Dreamshore as a brand name, and it's from a China-based company, but registered in the US. That was a bit confusing, Prof. Like, why do they register in the US, but it's a China-based company? And then out of the 700,000 hits, 10,000 of those are from the Philippines. Later, we'll see how we narrowed down the search for our analysis. Again, that's mainly because of the stars and the wavy lines. And even if we saw 700,000 plus results, I will only zoom in on, let me know if you see a striking similarity. I'll only zoom in on two brands I found that are most similar with Dreamshore. So we'll only focus on that. I mean, if ever we want to tackle it legally. So what our assessment is that legally, business-wise, strategy is strong. So it's really more of a branding and marketing strategy or the opportunity we're seeing, especially also since nowadays the 4-point star is now associated with AI. So the recommendation is to resize, take into consideration what hits the eye at first glance, and strengthen the trademark anchors because we're using common elements. Okay, for Sandbox, well, it's a big brand. It's poised to gain a cult following. The findings are very similar. The findings are very similar, but the brand is poised to gain a cult following, and they're raising the flag for the Philippines. So just quickly breeze through same elements. Um, Next, yeah, just same elements, clearing out duplicates. Okay, for this one, Chevron is a large owner of the Polygon, but does it matter to us? Not really at this stage because the Polygon, they just use the half Polygon. It's not strikingly similar. So we also zoomed in on the medical services field to narrow down the search to just 8,000 elements. And then, well, the first one, right. Yeah. So in terms of brand name, Sandbox, we saw 700 plus hits, and they're mostly related to programming, gaming brands, and then some of them, well, a lot of them already expired, and that's understandable because it's aligned with the definition of the word. And then next, thank you. Actually, in the Philippines, this is very interesting because there's one programming company called Sandbox Programs. Ateneo de Manila recently registered the brand. So I felt kind of sad for our emerging healthcare brand poised to gain a cult following. We learned something new, the Vienna classification. We're not going to dive in. Don't ask me questions. If you have questions, please ask Prof. Mario. But this is a striking. As a learning professional, I'm familiar with the taxonomy structure, so I see this as a visual taxonomy, very interesting. And then next. So these are the filters we use to narrow down our search, and similar to the recommendation for Giselle's brand. Our recommendation for Sandbox is to consider strategic branding, or since it's a booming, thriving business, do we disrupt that now? No, probably we want to enable corporate separateness. Actually, they already did that because there's already Prime, Sandbox Prime. So if I were the branding marketing manager, I'd say there's really big opportunity to make primer, make it more like optimum prime plus plus, and cover a wider market, and also strengthen the visual alignment and link it more to healthcare, less on games. Because if you look at it as an art, I don't actually see a polygon here. I see it's like two hands clasped, like the two C's, right? So if you well, our business owner is here.
So-
If I were an investor, I'd happily invest.
Okay, thank you.
Oh,
Para mag-zoom sa akin. Okay, right. So the logo actually means that there are two hands holding each other, and at the center is a box. Really just to point out that this is a safe space, you know. That's the meaning of sandbox that we've been talking about for the last few terms, just in healthcare point of view. Yes. License to touch.
many different parts.
All. Safe. That's oh my god, yeah.
Oh, yeah.
It's just it's a surprise that it only costs for my brand 4,000 pesos. So I'm going to stick to it and just register it, Prof. for 4,300 uh pesos only. There. 4,100 like.
Our main issue, Prof, was that the local the local website linked to a different search database. It seemed outdated, and then it didn't allow us to upload a logo. It was yeah, it was outdated, and it entailed manual work. So we were wondering why that was.
Thank you for the presentation. Have you paid for it already? Not yet. The logo of Sandma looks like is it the logo of Century, right? Century, a little bit. Is that registered already, your logo? No. Okay. Um, so it's good that you went beyond what the database says. And it's good practice for the reason that um, we have a jurisprudence on trade names. It's the case of Coffee Roasters versus San Francisco Coffee, which said that even if a trade name is not registered as a trademark, it still merits protection, which means that we're not really just restricted to registered marks. If a company registers its business name, let's say they secure a certificate of sole proprietorship from the DTI or certificate of partnership from the Securities and Exchange Commission, the name that's registered there, technically speaking, is also protected based on that case and based also on the intellectual property code provision that says that trade names are protected. Right? So that's one thing to keep in mind, right? That just because a trade name is not registered, it does not mean that it's not protected. However, note that there's merit, there's always value to registering the trademark to a trade name. So even if Jollibee is, I assume it's named as Jollibee Incorporated or something like that, even if they have it registered as such with the DTI or the SEC, there's merit to registering their trademark. And why? Why do you think so? Anyone from the group? Why is there merit to still register your trademark, even if technically your trade name is already protected?
My thought, Prof, is sometimes it's the logo, the mark that is catchy in the market. They might not remember it's the logo that means everything.
Okay. Fine. Trade name might not, when you register with the DTI, it might not capture the aesthetic elements of your mark. Another one is because you want to protect your mark for different classes of goods, right? And you don't get to do that with the trade name registration. You just name your business and then you have a function there, purpose of the business, but you're not really protecting the mark for different classes of goods. And as the groups have mentioned so far, the niche classification is vital. And we will discuss it later why the goods and the relatedness of goods are also very important in determining whether or not there's confusing similarity. So I would say that's it's good practice. Um, and so if Giselle says she's determined to register it, do you feel the same, Mina? You want to register it also?
Uh, we are going to push through with registration, Prof, but we're going to make some tweaks because we are, in fact, before this exercise, we are aware that it's a generic looking mark, and so we it's just that at the time that we're conceptualizing how it will look like, we're having a hard time coming up with a design that would tell our market that we are a rehabilitation service, because we ourselves are having a hard time to describe what a PT does or what an OT does or speech does. But uh, and so we just went ahead and say, okay, two hands and a box, and then let's go with it, and then let's conceptualize of how we can improve the brand as we go along. So that's it, bro.
All right. So I'm just curious, because there are a lot of supposedly confusingly similar marks, and so maybe there's merit to changing it a little bit.
Yes, Prof. Oh yeah, we intend to really register a mark, a trademark, but at this point, not yet. But we are going to, again. That is the intention, but not with this mark. But the problem is, in the medical community, at least within the Taguig, Makati, Pasig area, then that mark is already somehow uh, recognizable. So Y- yes, that was a kidding aside. Yes, sir. So, but yeah, so we're now having a hard time to uh, change it, but still retain the identity. We have to change it, but we know that the identity should still be there, or that it's hard.
So
Difficult.
Prime is the name of your business.
That no, that yes, but that is another clinic, because we're having a hard time selling the word sandbox to our adult clients. So we thought of putting up separating the adult and the pediatrics. So the adult unit now is called Sandbox Prime.
I see. All right. So just for the first two groups, did you notice the disclaimer portion when applying for a mark? Did you use it? For the first group in particular, do you feel that there might be use for the disclaimer portion? Wax, what is a disclaimer for?
For the disclaimer is if the brand name or the trademark has similarity hits or sometimes hits, you can put in the disclaimer that you're not claiming that the name or the title of that. For example, the international business law, since there is a hit for international business law, you could include in the disclaimer the international business law. Then
You're close. You're close. So a disclaimer is you're basically stating that you're not obtaining or you're not trying to obtain exclusive use or ownership over this particular statement or image. Right? It's you do that when, let's say for example, you're selling you're a hot dog stand. That's your business, and you want to apply for a trademark that says, let's say, Mary's hot dog and cheese dog products, something like that. That's your whole trademark. You cannot, the intellectual property office will not allow you to register the word hot dog. But they will allow you to register the entire thing. Okay? And the reason why they won't allow you to register the word hot dog is because, as we discussed last meeting, you cannot own a word to the detriment or to the prejudice of the public. So if it's directly describing what you're selling, you cannot have exclusive ownership over it. It's descriptive or generic. So what you will do is, on the disclaimer portion, you would include there a statement to the effect that the applicant is not not claiming exclusive ownership over the word hot dog except as shown in the entire mark, which means that you're telling them we're applying for this entire mark and we're not trying to claim exclusive ownership over specific elements to it or explicit elements of the mark. And so every once in a while, you'll get that um, dilemma, or you'll have that issue. But if it's like this for the second group, I don't think it's much of an issue because you're not really you're it's a dream shore is really for a different type of service, right? And sandbox is also not really descriptive of the physical therapy or the rehabilitation services. For international business law, it might be an issue, especially if you're the way you describe the mark. And that is another point, right? There is, if you're registering a logo, the platform will ask you to describe a mark. So if you state in that box that your mark describes the nature of your service, which is our advocacy is to spread awareness on international business law, then all the more the intellectual property office might say you'll have to disclaim the words international business law. So it really depends on what type of mark you're registering and what goods or services you're targeting. Right? So that's the purpose of the disclaimer, just for future reference, so you have an idea. For color claims, right? It's also very important, right? So every time your mark has a color, then you'll have to ask for a color claim, which will entail costs as well, but it's minimal. Now, but the question that clients would always have is, what if it's black and white? What if you do not claim for a color? Does that protect your mark? And the answer is yes. But technically, what you're protecting is the silhouette of the mark. So you're not protecting it as it is currently, as you really want to present it. What do I mean? If I'm applying for a trademark for the Asian Institute of Management logo, which you can see in front, right? Um, I would claim the colors yellow, green, blue, purple, violet, because that's my mark. Yeah. If I don't claim anything, then what will be protected is just the silhouette, the entire appearance, without really protecting the logo with colors. So it's a bit tricky, right? But always, no, always you apply for the mark as you want to use it or as it appears in your business or in your whatever it might be, your company or your advocacy. Now, otherwise, you're not able to protect it fully. So that's why color claims are also very important. Alex,
Prof, question lang on the disclaimer. How does it how do you apply that in actual practice? Is it something that is, of course, submitted to the IPO, but is there a requirement on how do you practice it or how do you enforce it? I'm just curious to know since I haven't really done any disclaimers in my
that's
practice.
a very, very good question, right? Because um, normally, I wouldn't disclaim. I wouldn't disclaim at the outset, right? Because if when I disclaim for my clients, then effectively I'm already limiting the coverage of the trademark. So if I can get away with not disclaiming the image of a tree, let's say for a farming equipment. Let's say I created the logo for a farming equipment, and my the logo of my client has the image of a tree. um, I wouldn't be too conservative about it. I would try to still apply for the entirety of the mark without really disclaiming. And I will wait until the intellectual property office tells me to disclaim the image of a tree, in which case the intellectual property office will issue a registrability report, and I will file a response to the registrability report, and I will simply state, pursuant to the order of the examiner asking for the disclaimer, I am hereby disclaiming exclusive use over the tree, except as part of the mark as shown. So I only do it after the fact, right? But that entails cost as well. Like for a lawyer, it's easy because you can easily file a response to an office action. But for ordinary business people who are not um, really familiar with filing responses, if you want your application to go smoothly, then having a disclaimer there would give a sort of a would increase your chances of having it registered. So there's a chance that there's no office action anymore because you went ahead of it. You went ahead of the issue and you already filed the disclaimer. So that's a good question because a disclaimer is effectively it limits the coverage of your trademark. So if you can do away with it better, but the examiners they oftentimes so they really do ask for these disclaimers. Another option is you can argue against a finding of descriptiveness or genericness. So if an examiner says you have to disclaim this because this tree is representative of a farm, now you can argue that no, it's not really. The farm that I am catering to is a rice farm. There are no trees there, and so I don't think the disclaimer is necessary. So you also have that option of arguing against the finding of the examiner, and there are times when it works. They eventually say that's okay. You can have this published, and then eventually it gets registered. So I hope I was able to answer your question.
Yes, Prof. Thank you.
All right. Other questions? All right. Thank you, LT2. Let's proceed with LT1 rather. Let's proceed with LT3.
Hello. Can everybody hear me? So good evening. I will be presenting our trademark search and application experience. I hope that the whole 6 minutes would cover everything from the search to the application itself. Okay. So our original idea was to apply for a trademark for a software app concept we had in one of our previous courses. The app was called Transit Plus, thanks to Wax. This is his idea. The idea was to create an all-in-one intermodal transport platform that would help tourists and locals in their daily commute. At first, Transit Plus sounded simple, catchy, and practical, something easy to remember and market. However, when we studied Philippine trademark laws, we realized that having a nice name is not enough. Under Section 123 of the Intellectual Property Code, there are marks that cannot be registered. For Transit Plus, the biggest problem is that the word transit may be considered generic or merely descriptive, especially because it directly describes transportation services. In fact, one of our company, Rural Transit, has an existing trademark. Also, even if it gets accepted, it may still be rejected if it is confusingly similar to earlier registered marks, especially in relevant classes like Class 9 for software and Class 42 for SaaS or online platforms. So from a trademark perspective, Transit Plus may be weak because it is close to a product description and is also in a crowded industry. So we had to step back and re-strategize. We realized we needed a mark that was truly distinctive and aligned with what we really wanted the app to stand for. That's when we identified our real advocacy, being planet friendly. Instead of simply building a transport app, we wanted to support a bigger purpose, which is sustainable commuting and travel. This is where Klimova was born. Klimova comes from the words climate and movement. It represents the idea of moving smarter while protecting the environment. Our tagline is smarter travel, lower impact. Klimova is a software app that helps tourists and locals calculate and choose the route which with the least carbon emission for commuting and travel. This is important because small everyday choices like how we commute can create real change. Klimova gives us people a simple way to make better choices one trip at a time. Klimova's main purpose is to help users compare travel options based on estimated carbon emissions. Some key features include low carbon route calculator, smart route comparison, multi-mode travel planning, and a way to track your impact over time. So the app is not just about getting from point A to point B, it's also about helping people travel responsibly. Now that we have a stronger and more distinctive name, the next step was checking if Klimova has a higher chances of trademark registration. Klimova is a coined term, which helps it make it more unique and therefore more registrable compared to common words like transit. So overall, Klimova is a stronger candidate because it is less descriptive and more brandable. So we tried using the WIPO. These are the search results. So when you search for brand logo, this will be the records or the search or the hits. But when you download the results, it will only just show you 180 records. Also, we tried searching for, we tried using the brand logo, similarity as to color, as to concept, and the other choices, and these are the more relevant results, but we really cannot, there was no results similar to Klimova. However, when we tried using the advanced search, this is what we got. So we discovered that there's a registered mark abroad called Klimova Boutique in Ukraine. So this is another dilemma. However, the question is, will this block our application, trademark application in the Philippines? The answer is not automatically. A foreign registration does not automatically prevent us from registering Klimova in the Philippines because trademark rights are generally territorial. It becomes a problem only if they are already filed or registered in the Philippines, or the mark is considered well known here, or the goods and services are related enough to cause confusion. Since a boutique is usually under fashion or retail categories and our app is under software and technology classes, the risk of confusion is generally lower. So after analyzing these points, we considered the dilemma resolved. We then proceeded to the next stage, the trademark application. We checked with the IPO Phil if here in the Philippines, there would be a hit. So when we tried searching for it, no results were found. So on to the next stage, the trademark application. So before applying, we prepared by watching tutorials and reviewing the relevant provisions of the NIST classification system because we need to correctly classify our good or service. During the application, we encountered some practical issues. For example, when we tried adding colors, when we tried adding colors, the system did not accept the inputs. Then we tried searching for terms here in the next step. When we tried searching for the exact classification using this search button, We tried searching for mobile apps, software, and technology for class 9, but no search results. So we thought it was because we were using a Mac laptop, but we tried using Windows and tried using other browsers, but still it won't push through and it won't search. So we assumed that the system was down. So, but we wanted to push through with it so that we'll be able to complete the process. And so what we did was we tried using this, the I want to provide my list link. So we tried inputting our own description manually, but even if we proceeded, we were not fully confident that our terms were correct. So when you will click that, this will be the you will be directed here. So we choose class 9 and class 42, and then we inputted the description, our own description, the downloadable mobile software application for class 9 and software for navigation. And then for class 42, it's software as a service or platform as a service, and providing scientific information, advice, and consultancy relating to carbon emissions. You will not be able to see it fully because it's kind of long. So after that, we then proceeded. We did not put the priority claims. We inputted our LP name for the applicants, no representative, and then we proceeded to confirmation. And then we also put a check mark in the declaration for small entity, and then filled up the detailed for the payer name and details. So after that, you'll be able to download, if you successfully filed, you'll be able to download your application, and then this will be what you will see in the document. So there's the applicant, the representative, modality, trademark type, representation, goods and services, colors, priority claims, documents attached, mark description. And then after that, you'll be able to generate the SOA. So for Klimova, it's 3,896.98.6. That's supposed to be paid if you really push through with the application. So, yes, Prof, sorry. So at the end of the day, it's push or not to push. Really, it's relatively easy online application process, very minimal requirements. However, there's a strong possibility of nice class terms misclassifications because of search error when inputting the type of good or service, because we manually added the description or classification. In the end, we will push through, but only after we personally confirm the classification with the Intellectual Property Office. That's it, Prof. Thank you.
Great, thank you. Can we go back to the priority, right? The slide with the priority, right?
It's here, Prof.
So why did you not sorry, the other one, priority date rather. Priority claim. Okay.
There.
Why did you not opt for that?
Because sorry, can everybody hear me? Because it says there, would you like to claim the priority of an earlier application filed in another office or country in the last 6 months? I was not able to find other claims, other applications, so I just skipped. I said no.
Okay. All right. So a priority claim is we're able to ask for that by virtue of the Paris Convention. So under the Paris Convention, under which the Philippines is a treaty member, we are allowed to, if your original application was filed in another member state, let's say you filed in India in June 2026, and then later on you file in another treaty member, the Philippines, in August 2026. When you file in the Philippines, you can choose yes here and you can invoke the India application because it's within 6 months. In which case, what will happen is your your application date will retroact to the earlier registration or the earlier filed registration. So effectively, it is as if you filed earlier. And the value of that is that you're able to, if someone else files an application for, what's the name again?
Klimova.
Klimova, then you can invoke that earlier application date to defeat them in terms of the earlier which in terms of the determination of which of the two of you filed an earlier application. So that's the use of a priority claim. So you were correct in not in saying that there's none because you didn't file anywhere else.
Yes.
But do note that you will see this every once in a while. For trademarks, it's 6 months. For patents, it's 1 year. So if you filed a patent application elsewhere in a member country, within a year, you can file in another member country and invoke the priority claim using the earlier filed application. Go ahead, you have a question.
Yes, Prof, just curious. Because you said that one is filed in India and then I am filing in the Philippines. And then if I invoke that priority claim, that claim will only be applicable here in the Philippines, right? Or will it be applicable to other jurisdictions as well?
What do you mean?
Um, because example, I mentioned in the earlier slides that wait, uh, um, regarding what do you call that? That if the one with if will this be a problem um in the Philippines with regards to Klimova boutique, and then I said there if it becomes only a problem if um how do I relate, the mark is considered well known or registered here, or that the goods or services are related enough to cause confusion. Wait, I'll just relate, Prof. Because you said that, example, if it's in India, and then we file a claim here in the Philippines, and if you have a priority claim, but the application is in India, so how will you impose that claim? Meaning, you will be imposing only within the Philippines and not in the Indian jurisdiction.
The Indian, the one in India, it's good to go, right? Because you filed the
Yes.
application there, so it's
Yeah.
early,
Yes.
right? So that applies in the Philippines because you filed the application in the Philippines at a later date. And
Mm-hmm.
effectively, what you want to do is to move it earlier.
Mm-hmm.
You want it to be a little bit earlier for whatever reason. Sometimes there's a legitimate reason, such as when there's another company who happened to have filed earlier than you, maybe by a month.
Mm-hmm.
In which case, a priority claim would be very beneficial because you're gonna tell the intellectual property office the application date for this should retroact to June 2026.
So even if the Indian company did not apply here for a trademark registration, you will still be able to enforce that priority claim, Prof.
Do you mean to say the company that the Klimova company? Or so
Actually, I'm thinking of that, Prof.
we're presuming it's the same company, right? It's not an Indian company. It's you. So you
Okay.
applied in India first, and then within 6 months you applied here.
Okay, I thought it's a separate company.
No. It should be the same entity.
Yes,
Yeah, it
okay.
should be the same applicant and the same registrant.
Yes, I now understand, Prof. Thank you.
Okay, so can we go to the priority examination, the slide with the priority examination? Okay.
Wait, Prof.
So, two things here. The declaration of small entities, it's you're able to ask for that if the company is worth 100 million or below. Right? So if the assets of the company is worth 100 million or below, then you can declare that the company is a small entity, in which case the fees are slightly lower. Right? It's not so substantial, the decrease in fees, but it adds up because later on when you file a declaration of actual use, that same categorization will be applied. So if you want intend to keep your mark for in perpetuity, then you may want to declare as a small entity, especially if it's not a huge company, right? So it's only for purposes of smaller fees. Before, they used to ask for an affidavit proving that you are a small entity, or an affidavit on your end that states that you are really a small entity. But nowadays, they don't ask for it. They change the rule. So you can just tick the box. For a priority examination, this is available under certain circumstances, and actually the the platform provides for it. No? Rule 605B of the trademark regulations. So there are certain situations, such as when, let's say, your mark gets abandoned because you are not able to file a maintenance or a declaration of actual use. No? So it gets removed from the register. Now, when you're unable to file a DAU, as we call it, automatically, without warning, your mark gets removed from the register, and you have no option but to refile your trademark application. In such instances, you can ask for a priority examination, and so you'll be, when you refile it, you can tick this box and say that I'm simply refiling this trademark application because our mark was removed because we were not able to file a DAO. So that's there are certain cases when you can you can ask for a priority examination, which supposedly makes the process a little faster. But generally speaking, trademark application should not last long if it's not contentious. I've had experiences whereby it's maybe 6 months or even less. A trademark can be registered, but if there are many confusingly similar marks, then that necessarily prolongs the process. Okay, so that's it. Any questions? Questions to other groups? Go ahead, AJ.
Can I be allowed to
Of course.
put some input? For me, Prof, I didn't input too much on it because I'm a foreign company that have different experience from my cohort from LT1, LT2, LT3. So I came here in the Philippines in 2017, so I applied for trademark on 2018 for my business. But my business is existing back in Singapore as a solar net metering services for OFW. So I bring a registered trademark here in the Philippines and bring the business here in Singapore and registered in a Commonwealth country. Filipino are not part of the Commonwealth country that has different jurisdictions and laws here. So when my experience of application here in the Philippines, I'll be honest, I commissioned a company that do this kind of stuff. But it was a good lesson learned for me because as a foreign company, we cannot just go through a typical that being mentioned by LT1, LT2, LT3. We were compulsory to be engaged in a system during our application called Madrid system here in the Philippines. And that Madrid system protects my logo and trademark because I have if I go to a local process that mentioned by this group, I have a lot of hit because my name of my solar company was Organic Solution. So means I have a hit on wellness, beauty shop, and soap and something like that. So since my logo and trademark is existing, there was advice here in the Philippines to put under the name and the logo, which is a solar networking on a grid net metering services. So it's to put something to complement that this is a solar and this is a net metering, not a soap or a wellness shop or something. So this lesson learned from Madrid system was good for us because it protects us 120 countries to hit. That's why probably that mentioned of your discussion about the India. It protects us. That was a good thing for us to be advised. And then we pay a different cost, a higher cost for that. And I agree with you. Sometimes it goes to 6 months but we commissioned an entity, especially for this. It was 2 to 3 months timeline of turnaround. And aside from that, after this Madrid system, we were obliged to say DAO for IPO registration of our trademark. So I cannot go into detail, and we were required for a defense cost and a coverage of infringement defense and protection again. So we commissioned an insurance company back in Singapore, AON, to cover also the Philippine business thing. So that's all a share of input, which differ from our teams.
All right.
Thank you.
Good. So that's a very good insight. I was just earlier today, I was discussing the Madrid protocol to a client, and that's the benefit of it, no? So let's assume, Candy, you were not able to file the application in the Philippines within 6 months. India is also part of the Madrid protocol. So now what you can do is you can file a Madrid application invoking the registration in a Madrid country, and so effectively you're anchoring your application in other jurisdictions from the Madrid, the home application as they would call it. And so effectively now what you will do is you will designate countries. So example, the Philippines, countries or territories, or let's say for territories, the EU. You can designate these territories, and what will happen is you can either submit the application through the Intellectual Property Office of the Philippines or directly file it through the Madrid platform. And then WIPO, the World Intellectual Property Organization, will conduct a formality examination. They will try to see if the documents are all there. And then if they see that it is, they will forward the applications to the respective countries. And that the countries will now conduct a substantive examination. So they will now try to see if the application will actually be legal or valid based on their um, IP laws, right? So and then effectively, if there are no issues, then you need not even hire a lawyer, a foreign lawyer, and you can actually proceed to registration ideally. But in my experience, well, there's oftentimes there's something, so you would still have to hire a foreign agent to respond to the office action. But we will have a session on the Madrid Protocol and on the Patent Cooperation Treaty and on the Berne Convention, so we can discuss it further then. All right.
Prof, last one thing I may forget to share to the team. My DAO is only 3 years under Trade Regulation 17010. and we have to renew, and it depends on the business status or something, performance here in the Philippines. Just a note to the team. Thank you.
Thank you, Prof.
Set up.
Right. Can you ask for uh, connector? All right. So, so we ended our discussion last meeting with trademarks, a very brief introduction on trademarks. So, we will go a little bit more in depth this evening. And I did assign two cases, which are very helpful, for, as starting points whenever we talk about trademarks. So before I proceed, just a recap, very short recap. Um, Always remember the definition of copyright. No? Copyright is the legal protection given to owner of original works or creators of original works that are either literary or scientific. And we did mention a number of examples, that would fall under copyrighted works. Now, I think I was not able to go over this article last meeting, but I did discuss it a little bit um, two meetings ago. And so this has to do with Taylor Swift, right? Taylor's version, which anyway she was able to repurchase. So it's moot now. But the reason why she well, supposedly, based on the article, the reason why she created Taylor's versions is because just like any other starting artist, when she was starting out in the music industry, she signed, no? She had to sign a contract which was presumably unfavorable to the artist and more favorable to the production company. And so when that happens, of course, as you learned in contracts, so some contracts are just skewed in favor of one party, and sometimes you have no choice but to sign these contracts because you want to be successful, in your field. And so, in her case, she had to sign this contract with her production company, and what happened was she effectively had to she lost part of her rights over her work. But lucky for her, there is a provision in the intellectual property law or the copyright law of the United States, which allows artists to re-record their um, compositions or their works, and for as long as they re-record it separately from the original recording, meaning they don't use the original recording in any way. Right? They're allowed to do so, and that's what she did. She re-recorded her music using now her own resources, and with that re-recordings, she rebranded sort of these new songs. And the recordings were also somewhat different, no? So if you listen to Taylor Swift, no, some of the songs, Love Story was different, right? A little bit longer, maybe. And so eventually she was able to not only rebrand or re-record, but also to ask her listeners, her fans, no, to really just support her own uh, her own versions of the songs. And so it's a very interesting article because it shows you how artists are able to regain control over their work through the use of intellectual property law. And another, I suppose, no, another important note there is that um, Taylor Swift writes her songs, right? So she also owns the copyright over the lyrics of the song. And so if let's say a movie wants to use one of her songs, no, Taylor is able to veto that because at the end of the day, she also has to sign off as the lyricist, the copyright owner over the lyrics to a particular song. Um, and so if she's able to veto use of the original version, then she can also recommend the use of her version. And so effectively, she can veto the use of the original song, and then eventually, let's say a production company might opt for the Taylor's version instead, because now she's not just the owner of the copyright over the lyrics, but she's also the owner of the recordings. And so that's very interesting, how she approached it. But then again, no, she was able to buy the entire record back. So fair use, no? So it's a bit complex, the discussion, but just take note of these four factors, um, and the nuances, no, behind them. No? So again, no, when you try to assess fair use, you'll have to, the most important factor, as the courts would always say, would be the fourth factor, which is whether or not it has an effect on the potential market for or value of the copyrighted work. So, does it, are you using it for profit, for instance? And are you actually using it as a substitute for the original work or as an improvement of the original work? If it's prejudicing, if it somehow affects the marketability, the value of the original work, then chances are the court will say there's no fair use because now you're actually hurting the original work. But aside from that, you'll also have to assess the other factors. What's the purpose of the work? Right? Is it, are you using it for profit? Are you selling it, or are you just using a parody, or you're just using it as a critique or to make a parody of another work? Right? If it's a parody, then the courts will lean towards fair use. But if we're using it for profit, then chances are you won't be able to hide under the fair use doctrine. And to me personally, whenever I watch YouTube videos, and a lot of YouTubers are actually not so sensitive when it comes to copying or lifting works of others. Whenever I see these videos and they have advertisements and they have so many followers and it's clear that they're earning from their channels, then it makes it difficult for them to argue for fair use because clearly they're earning a lot from their videos and their videos are for profit. effectively because they have advertisers or sometimes they're even selling their own products, right? Certain creators like Mr. Beast, they have he has his own chocolate branded toys, right? So the question always is, what's the purpose of the use? If it's for a channel from which you're earning, then it's very difficult to allege fair use. Second factor is the nature of the copyrighted work. If it's a composition, then there's a high level of originality involved. But if it's a biography or a report, then the originality involved is a little bit lower. In which case, then it's harder to allege fair use. And again, the amount and substantiality of the portion used is also relevant. If it's just a word or a line, then maybe just maybe, you can argue that it's just fair use. However, again, note that there have been decisions in the United States whereby the court said that just because it's a line does not mean that it will automatically fall under fair use, because sometimes that line is so valuable and it goes to the heart of the material. Note that there is a recent decision by the court, I think just released a few months ago, the Philippine Supreme Court, whereby it took account of the substantiality to argue or to decide that in fact the copying fell under fair use. In that case, what happened was there was an establishment that what they did was they played. I think they have a website and they played a portion of the song, but just the start of it for promotional purposes. Now, according to the court, that is taken into account when we decide on fair use, because now if you're just really trying to promote the work and trying to give a glimpse of the work, then that's very minimal, and it also helps the copyright owner or the author of the work. And so in that case, the court took into account factor 3 and actually said that it can fall under fair use. And so again, amount and substantiality can matter, but you'll just have to find out what exactly is being copied. And again, the effect of the use of the upon the potential market for or the value of the copyrighted work, we discussed that in Pretty Woman, because Two Lives Crew, they weren't really trying to get the market or steal the market of Roy Orbison. No? Clearly, they were just doing a parody, and so the court took this into account in deciding in favor of fair use. There are other limits to copyright use or copyright ownership. Again, if the work is being used for public purposes, we have provisions for that. So if it's a reproduction and communication to the public by mass media and current political events and other works which are delivered in the public, if such use is for informational purposes only, it could fall under fair use. And at the same time, if you're trying to preserve the work, if it's a national library, let's say, getting a copy of a book for purposes of preserving it, then that would also fall under a limitation. So aside from the fair use doctrine, there are explicit provisions under the Intellectual Property Code that allows for reproduction of works without fair use, or rather without infringing. So that's if you want to know more about this, you can look at section 184 of the IP code. Okay. Questions so far about copyright before we go ahead, Wax?
Rob, is there a certain threshold for the author or the creator of the copyright on how much they would ask for the person that would use their works?
Is there a threshold on the part of the author? Can you clarify?
For example, I create a song and other person would like to play it in their restaurant. So how much could I charge them?
Okay, how much will so so usually it's there's a an organization that handles the copyright and other rights of the artists. PhilScap is one of them, right? So what you do is you go directly to PhilScap and uh, they would have packages available for licensing of their artists, the works of their artists. Now, based on interviews that I've done with certain business owners and artists themselves, um, I understand that for, let's say, if it's a 1 year license that you need, then there are discounts available or packages that make the package more appealing to the business owner. So that's it depends. No, it depends. So, but an alternative is really creating your own music, your jingle, or hire or um, asking independent artists. Some independent artists they do not fall under any organization or they do not ask any agency to handle their copyright. In which case, they're usually a little bit more, lax when it comes to use of their work. And some artists, I did this article for the Inquirer before on when this decision came out a few years ago, whereby I discussed the repercussions of the Phil's Cup versus Anway case, and I was surprised to find out that some artists were against it because they felt that it necessarily limits the exposure of their songs. So it really depends, no, on the artist. Though the
Good evening, Prof. I just would like to ask about the government. If it uses copyrighted materials, could it be sued?
I would think so. I would think so.
Mhm.
Uh, because although government does not have copyright over their works, the law does not say that they can use copyrighted works without consent.
I was thinking about sovereign immunity. Yes, Prof. And also when let's say politicians use the jingles in their jingles, the melody or the songs of artists of yeah. So I was thinking about that and the government's use. Thank you, Prof.
Politicians for sure, right? Because in fact, recently in the last elections, the IPOFIL and COMELEC came up with a resolution, with a joint resolution, reminding candidates, no, to respect the copyright of the
Mhm.
of the artists. No? But for the government agency, I would assume you can file for damages if an agency use your work. And I think there have been cases just recently, right, of agencies caught copying, lifting photos, etc. from the net. Okay,
Oh,
30-minute break, and then we will proceed with discussions on trademark. Thank you. Thank you to all the groups who presented. All right. Okay. So, as we discussed before, a trademark is a visible sign capable of distinguishing goods or services. So again, it's a visible sign. So in other jurisdictions, scent is can be considered as a trademark. In our jurisdiction, not yet. For now, we'll have to uh, in order to be registered as a mark, it should be something that's visible. It should be something that's capable of distinguishing. And so, because of the second requirement, we're not able to register marks that are descriptive or generic of the goods or services that they describe. Now, it's called a trademark if it's used to distinguish goods, but if it's distinguishing services, then it's called a service mark. So again, this is different from a trade name. A trade name is the name given to a business or enterprise. And again, as I mentioned earlier, you may want to look at um, coffee roasters versus San Francisco Coffee, which discusses that a trade name is protected even without registration. No? So trade names are also considered as a type of intellectual property asset, and it's protected again without the need for a registration. Now, before we ended last meeting, we discussed the different types of marks. And so when you simulated the filing of a trademark application, you were able to see it. A figurative mark is usually used to apply for a logo, right, or a picture. Right? Now, if there's any word that accompanies that figurative mark, then that is considered as a figurative mark with words. Others would call it a composite mark. Others would call it a holistic mark. Now, note that when you file an application, even if the mark does not really, let's say it's um, GVN, no? An example of a brand, no? Even if GVN does not refer to any particular word, you will have to apply for it as a figurative mark with words. So even if it's letters, the intellectual property office will oftentimes require you to still opt for a figurative mark with words instead of a figurative mark. So they consider letters as falling under words. So if letters accompany the image or the logo, this is the type of mark that you'll have to apply for. And of course, you have the word mark. Okay? So there are um, advantages and disadvantages to these types of marks. What do you think would be the advantage of applying for a word mark? Candy.
It can be easily distinguished, Prof.
Can be easily distinguished. How so?
Because it's a word, that means you can search for it easily. Whereas if you comparing it with a mark,
Mhm.
it's like there's an added process of uploading the logo and then looking into the logos that will come up with the search. And like if it's Word, you can just type it or search for it, and then because of the technology today that can read words and letters, it will be easier.
Okay. So I agree. I agree that it might be easier, but there's another reason why word marks are often preferred. Shruti?
Prof, is it to protect you against counterfeits? So you're the only one allowed to print that name on items.
Okay. All right. So yes. But before I proceed, Wax.
I think from the advantage of word mark is that uh, if a competitor try to register in a figurative mark with words, they
Mm-hmm.
may have a problem since you already used the name.
Mm-hmm.
So they have to disclaim or not register the name of in that figurative with words.
Okay. You want to add to that, Janet?
Yes, Prof. I think the advantage of having of registering a word mark, it will count already as an infringement, regardless of the style, for as long as the word is used in by other competitors.
All right. So let's say I have very terrible handwriting now, so I'm opting against it. But let's say you use the term But okay, AJ first and then Alex, no? And then I'll proceed.
Yeah, I just want to add, Prof, like the NBA logo. When you say NBA, it's specific to the basketball league in back in the States, and they sell a lot of merchandise and different subcontractors, so it protects them and easy to understand and identify.
All right. Okay. So even without the logo, if you apply just for NBA,
Yeah, it's a non-national. It's not the PBA, it's the NBA, something like that. You know, you can compare that is from the States.
okay. Thank you, AJ. Alex.
Prof, I just learned this from the Fujifilm word mark itself. I think it's more advantageous because a word mark protects the words themselves, regardless of how they look. So that means we can stop others from using Fujifilm, which are confusingly similar. And also, logos, they do evolve. The fonts change, rebranding can happen, but with wordmark, we can redesign the Fujifilm logo freely without losing the protection.
All right. Okay. So that's primarily the reason, no? What Janet and Alex mentioned, no? Which is if, for instance, no, you go with another trademark of Nike, just do it. You have the option when you apply for a trademark, you have the option of applying for a logo, even if your mark is just do it. And you do it by using a particular type of font. So what will happen is when you file an application, you actually upload a logo of the term just do it in a particular font type, in a particular color, and that's your trademark. If you do that, what you're applying for effectively is a figurative mark with words. Even if it's just the words just do it. Because what happens is you're actually applying for a specific way by which the words just do it is being presented. So that's an option. However, certain trademark owners would not want that. They would still prefer to have an application or a registration for simply the words just do it. And the reason is because if you apply for a word mark, then now it doesn't matter how it is written. If you get the registration for that slogan, then you have exclusive use and ownership over that entire term. And so if other companies write the words just do it for their products or for their services, and even if they change the color to a color that Nike never uses, let's say, or seldom uses, let's say they use the color pink for the term just do it, they cannot now allege that their mark is different from Nike's because it's pink or because it's written in a cursive manner. Because if Nike has the registration over the word mark, just do it, then it does not matter how just do it is presented. It is protected as is, as a set of words arranged in such manner. Right? And so other companies would want to apply for a word mark. But there are also disadvantages to it. Right? What do you think would be the downside of applying for a word mark? A word mark gives broad protection, right? But just like anything that's good or that's desirable, usually they're hard to obtain, right? It's the same thing for word marks. So usually if you're applying for a word marks, there's a high level of scrutiny on the part of the examiner because now they'll have to make sure that they're not allowing you to appropriate words that should belong to the public. And so the level of examination is, I would say, a little bit more stringent. So they'll have to check that in fact, just do it is a slogan that you came up with, that it's original to you, that it's connected to your company. It's not, let's say, it's not a saying that was popular in the 80s and now you're just trying to appropriate it. Right? So they'll have to make sure that it's not descriptive, that it's not generic, or that it's not being applied for in bad faith. Right? So even if it's always, I would say it's most of the time it's preferable to go for a word mark, it's also not always easy to obtain a word mark. And, okay, go ahead.
Just curious, Prof. Um, what if, hypothetical, what if in the Nike logo, because you said there it's a figurative mark with words. But how about example if you disclaim the word Nike, when it changed the classification to just a figurative mark?
Okay, a disclaimer does not affect the the classification of the mark. So even if let's say it's a tree in the farming example I gave earlier, it's a tree and let's say the name of the company is Cylone, some random term with the tree. The tree is the only image, right? And you want to, if it involves the forest or agriculture, you feel that you have to disclaim it. You disclaim it. Even if you disclaim it, you still have to apply for a figurative mark with words. And in fact, when I say words, Nike is also considered a word. Right? So again, no, usually the examiner won't discriminate whether or not it's a word that has a dictionary meaning or if it's a coin term. If it resembles, if it's a set of letters that resembles a word or any term, then they would consider it as a word and you should apply for it accordingly. All right. Very important case. Zuneca versus Natra Farm. Anyone care to explain what happened in this case? Very interesting case too. Right? I'm sure you've read it. Brave souls, you're nodding. And they would you want to
I've honestly read the case, but it was last week.
I'm sure you still recall it, right?
Yes. Okay po. One of them. Wait. Who's the Zainaps with E?
Synapse with E is
Uh, wait lang, Prof. But among the petition is Zuneca. Okay, there you go. Okay, so Zuneca is a pharmaceutical company, and they are trying to register the name uh, Zynaps. It's spelled as ZYNAPS, which is one of their drugs.
mhm.
Excuse me. And then, however, when they are trying to register their drug, not native farm, Natra
Natra
farm.
Farm, Natra, I'm not actually
Sorry po,
sure how it's
Natra
called.
farm.
Natra Farm.
um, Alright. Okay. Natra farm opposed.
Mm-hmm.
Wait, who's see, Prof,
Andy is asking
I'm
for help with the specifics of the case.
just
Anyone?
Doctor, may I help
just
my
the
teammate?
fact.
Go
Yes.
ahead, Dodi.
Yes, Prof. I made notes so that I will not forget. So there was of the mark Znaps or Zynaps, Zunica had been using the mark since 2004, but did not register the name, the mark, with the Intellectual Property Office. But here comes Natra Farm, which is another company who was able to get a very similar trade a mark registered with the IPO later in 2007. So because it was able to register, Natra Farm was able to register, it is now trying to it filed a case against Zunica uh,
For
brand.
infringement.
Yes, sir, Professor. Yes, to
That's
stop it from using the Zynaps. the other one, the name. So here there is a first to file by Natra Farm,
Okay,
but
so let's.
yes, Prof. But it was Zunica who was first to use.
Mhm.
Yes, Prof. So those are the facts of the case.
Thank
It's
you, Dodi. You want to continue, Andre?
So wait, it's no.
All right. If do you recall, are these two products being used for the same to treat the same sickness?
No.
Okay. Zunicas is being used for.
One of them is being used for as an anticoagulant.
Okay.
The other is used for wellness.
Okay.
Uh,
Is that sa uh,
uh,
uh, one is being used, anyone care to, one is being used to treat epilepsy, seizures. Right? That's the one by Zuneca. Right? Natra Farms was different. It's being used to treat strokes. Right? So, it's a bit different different types of sickness, but in any case, both are pharmaceutical products. The way they're written, would you say are they confusingly similar with each other? Zynaps and Zynaps with an E? Very much so, right? Remember, when we assess confusing similarity, we don't just look at or we don't just consider the visual differences. Oral connotations are also important. So how you read them and how they are pronounced, those are all factors that are considered when assessing confusing similarity. Now, we have a very peculiar situation here because you have a company, Zuneca, who's claiming that they were the ones who actually created the mark and supposedly they used it before Natra Farm. Zuneca is a company that's, what does Zuneca do? It imports medicine from Pakistan, distributes it in the Philippines, and Zynaps was one of their products. But according to them, they weren't able to register it. In the testimony of the one of the owners, she said that she was, I think, sick at the time or was taking care of someone who was sick. And so she said she wasn't able to register it with the Intellectual Property Office. Natra Farm, on the other hand, used it later, a little bit later. It's a domestic corporation, use it for a different type of sickness, but they happen to register it first. And so, in fact, in this case, it was Natra Farm who filed the case. Natra Farm told the court, Zuneca should be prohibited from selling this product. And in fact, they're infringing upon our registered mark. And then Zuneca filed a counter complaint saying that Matra Farm registered the mark in bad faith. What did Zuneca say exactly? What was their defense? Go ahead, Candy.
I think Zuneca was trying to say that um, they were both the products were both advertised in a magazine. So because Natra Farm should have known that they were already using the signups mark because of that magazine. I think it's a magazine.
Mm-hmm.
Uh,
It's like I don't know if health practitioners. It's like MIMS. I think the MIMS, the booklet for
Catalog.
the catalog for medicine, prescription medicine. Yeah.
Yeah, so they were saying it's bad faith because Zunek, uh, Natra Farm should have already seen that mark using that catalog.
Okay, so they said that we publish our products in the same catalog. And so it's impossible that Natra Farm did not see our Zynaps mark before they registered it. Aside from the catalog, what else did they invoke?
They participated in the same convention years prior.
Okay. So they said, aside from the fact that we publish in the same book, we also attend the same conventions. So much so that Natra Farm, when they filed the trademark application, even if they were first, they already knew that we had this product. And so they were alleging effectively knowledge on the part of Natra Farm that Zuneca's Zynapse mark is in fact already present. It's existing. They were just copying it, right? And so now, that's the crux of the case. Right? The question that we have here is, who do you really prefer? Who will win in a case between a company who's supposed to be the creator of the name, a prior user, use it before the other one, or should the company who registered it first prevail? Right? So it's sort of a battle between the prior use doctrine and the first registrant doctrine or the prior registration rule. And according to the court, through Justice Kagiwa, and remember at the time, the court kept on flip-flopping. So the court was not sure whether or not to follow the first to file rule or the prior use rule. And so there's a bit of a confusion. Some examiners would say that it's the prior use rule that should govern, meaning to say the first entity to use this mark gets priority. But others would say it should be the first entity to register it. And eventually, in this case, the court ruled decisively. So they said that they invoked this provision, Article 123.1, subsection D, to say that under our existing code, the Intellectual Property Code of 1998, the mark that will prevail is the one that is registered first or applied for first. And now we refer to this as the first to file rule, which effectively makes trademark registrations sort of a race. Now it's a race to registration. Either you register it or you lose it. You lose it to someone else who gets to register it first. And so that's the importance of this ruling. But aside from that, this doctrine was also being questioned. Right? Because there were a lot, there's still criticism of this doctrine today, the first to file rule. Because what do you think is the problem with this doctrine, if anything? Or do you find that this is totally a fair rule? Go ahead.
Because what if the first one who registered in bad faith, meaning the first registrant already knew that someone else was using the same trademark or trade name, so but still since it's first to file, he was still the first one to file. So using the first to file rule, he has a better right over it.
All right. So that's the main criticism. Candy wanted to add to it. So that's the main criticism. By making it a race, you're now opening the floodgates to companies or entities who are just filing for the sake of maybe preventing the others or maybe appropriating a mark that's not really theirs. Some would even appropriate the mark because they want to sell it to the real owner. And it has happened before. And so now it opens the floodgates to what we refer to in practice as trademark squatters. Entities who squat upon the trademark just because there's no registration yet. Another problem with this doctrine is that some businesses, no, they opt not to file an application right away. So they don't trademark is something that's really far from their thoughts because they want to establish their presence first. They want to make sure that their company is viable. But the moment it becomes popular, someone jumps on the opportunity and applies for it even if it's not theirs. And so now you have sort of a problem. With the prior user rule, that was not so much of a problem. Under the old trademark law, which is the Republic Act 166, we used to follow the prior use rule, which means that when you file an application, you also have to prove that you were the first person to use it. And effectively, that gets rid of applicants in bad faith because now you have to show that it is really yours, that you actually created it and that you've been using it. But now with this rule, with this decision, that's no longer the case. You just have to be the first one to file. And the way the court resolved this issue is by saying that even if we have the first to file rule, that does not mean that all trademark applications or even registrations are necessarily valid, even if they are filed first. And the reason is because, according to the court, our intellectual property code disallows trademark applications that are filed in bad faith or fraudulently. Okay, now what do we mean by bad faith? Bad faith is a trademark application that is done while having knowledge of the prior use, prior creation, or prior registration of another mark. In other words, let's say even if Levi's does not have a trademark registration here, that does not mean that another person can just file an application for the mark Levi's. Because under this rule, if it is proven that that person is actually aware already of the mark or of the brand Levi's, then effectively he or she is filing the application in bad faith. So once you are just copying, then that means that you're actually a filer in bad faith. And your mark or your application is null and void. It has no effect, which makes it susceptible to opposition or to a cancellation, which I will explain later. Another ground for having a mark cancelled is fraud, which is making false claims about your mark. So what do we mean by this? No? Let's say you file an application for a mark with the Intellectual Property Office. You use the platform. And then later on, the Intellectual Property Office came up with an with a registrability report, and they told you you cannot apply for Levi's because effectively you're falsely designating the origin of your mark. So we have a provision in the Intellectual Property Code, which I'll explain later, which says that you cannot put any institution, living persons into disrepute. So effectively, I cannot apply for the mark Harvard because effectively, I'm misrepresenting myself as the owner of the Harvard University or as someone associated with Harvard. So the examiner might say, "You're not. Why are you applying for Levi's? It's a living. It's an active institution." And what the examiner will do is ask you to execute an affidavit saying that you are not, in fact, copying Levi's, and in fact, you're applying for your own brand that you created. That affidavit that they ask you to submit, if it is proven later on that you committed a misrepresentation in that affidavit, then effectively, you're committing fraud in the process of applying for your trademark. So anything that you submit that is not truthful, that's a misrepresentation, that could cause, again, a cancellation of your mark because that's an application that is made fraudulently. And the court said that bad faith and fraud come hand in hand with each other. That the existence of one necessarily presupposes the existence of another. Okay, so that's one of the decisions, no, made in this case. Dodi, you're raising your hand, or was I able to answer the question already?
Yes, Prof. I think there was another issue in this case. I think it was the existence of good faith or bad faith uh, on the part of the first user. I think that
Mhm.
and the issue I think is this: can a prior user in good faith be held liable for trademark infringement against the first one who had the mark registered?
Mhm.
Yeah, so the RTC and the CA, the lower courts ruled that um oh no, the Supreme Court ruled that the first to file rule is upheld because I don't think there was a discussion of the whether there was good faith or bad faith on the part of the first to one to register, but there was good faith. The Supreme Court found good faith on the part of the first user, in which case he was allowed to continue using the mark that he first used, even though the owner of the registered mark is the first to file. So the Supreme Court had, in my view, made a Solomonic decision here. The Supreme Court gave the ownership to the one who first filed, but allowed the first user to continue using the name. So it's really, for me, it's a nice decision of the Supreme Court. But the Supreme Court also uh, read together provisions of the IP code together and not in isolation. So although it was clear that the first one to register is the one who filed, oh, the owner is the first one who filed, but there was another section mentioned in the IP code which gave the prior user in good faith the right to use. Uh, so he could not be stopped from using the mark, even though the first to use is not the owner of the mark. So
All
I think
right.
thank you, Prof.
Okay. So I'll get to that, Dodi. Very important point. No? So effectively, what do you get when you register a mark? You get the right to prevent any party from using the mark without your consent. That's why it's important. Because once you're able to get the registration, presumably you're the owner of it and you can prevent everyone from using that mark, at least in the territory or jurisdiction where you're in. The problem is, one of the problems at least with this doctrine is, what about those businesses, entities who were using that same mark in good faith? They didn't know that another person will be using it or will be registering it, but unfortunately they failed to register the mark. In other words, they're in good faith. They did not copy. They have been using it. In fact, their use predates that of the registrant, which is precisely the situation where Zuneka finds itself. Zuneka clearly was able to establish that in fact it created the mark Synapse, the one without an E. They even presented how they came up with it. They said that they were thinking of the neuron, and then they were thinking of how the gaps in the neuron plays a role, etc., etc. And so clearly they were in good faith. The court here said, well, that's not a problem because according to our intellectual property code, we do have the prior user in good faith rule, which is section 159.1, which says that if you are in good faith and you've been using the mark before the filing date of the other mark, the one that's registered, then you will be able to continue using it. Right? You won't be accused of, you cannot be held liable for infringement. And so now you get this benefit. However, there are limitations to it. You can use it, but you cannot register it. Registration belongs now to the other person. You're simply allowed to continue using it. Another limitation is that you cannot sell that mark or you cannot license it to another person. Because according to the court, or at the very least, you cannot transfer it. Because according to this provision, you can only transfer that mark if you are transferring the entirety of the business. So in the case of Zuneca, they cannot deal with another pharmaceutical company and just sell the name Zynaps without an E. Because according to this rule, they can only transfer the rights over Zynaps without an E if they're transferring their entire business. And so now effectively, even if you're allowed to use it, you're not really able to own it as a personal property or something that as an asset that you can just deal with freely. Because effectively what you have is really more of a concession, more of an exception that with the court allowing you to or with the laws allowing you to use it simultaneously with the real owner, with the registered owner, but that's about it. That's about it. You won't be liable for infringement, but you can continue to use it. Carol?
Question for the first person or the company who uses the name, who was in good faith, was there a limitation of duration until when they can use the said name?
No. There's no mention of any duration for as long as it stays with them. And if they're merging with another company, it should be in its entirety. It should be merged in their entirety or it should be sold in their entirety. Now, if you're that company, you can hope that the other parties are not able to file a declaration of actual use. If it gets abandoned at any point, then you can file an application and then you can own the mark. But until that happens, and usually big companies are they monitor these, no? They make sure that they're not outside of the deadline. Until that happens, you're constrained to just this rule, enjoy the benefits of this rule. Alright, so that supposedly answers one of the issues. But to me, there's another problem. Okay? For me, there's another problem with this rule that a mark cannot be registered if it is applied for in bad faith. What do you think is problematic with this? Although I think it's a bit difficult to answer, no? But
Professor,
since this came, go ahead. You want to try, Dodi?
I want to try, just try, Professor.
Go ahead, go ahead.
The bad faith really here does not really mean immorality, in my view. It just means that the one who first registers or files for registry is aware that there is somebody using the mark, but who has not registered it. Precisely, I think that the law allows that. And I think it's uh, a more stable rule for the law to maintain. So for me, bad faith there is not really evil. It's just it just signifies that the first to register was just aware. It doesn't really mean that he is bad or evil, in my view,
So
Professor.
you feel it's a misnomer?
I think so,
Bad faith.
Professor.
Okay. All right. Thank you for that. Well, it's a good point. But to me, there's a bigger problem. And I've experienced it in how many opposition cases now since this ruling came out? Which is certain companies, um, there are a lot of companies abroad in foreign jurisdictions who are simply not able to apply for a trademark registration in the Philippines right away. simply because we're not the most ideal market for them. Right? There are bigger markets available elsewhere. It's clear they'll prioritize those markets. And it so happens that someone else registers first. Now, if you're that big company, the real originator of the mark, you have no option but to have the registration, the local registration canceled or opposed. And to do that, you'll have to prove bad faith. And bad faith is not so easy to prove because you'll have to prove knowledge of prior creation, knowledge of prior use, and knowledge of um, creation, right? You'll have to prove knowledge on the part of someone that you don't even know. How do you know that this person or this entity actually had knowledge of your mark? Right? The law does not allow for exemptions. You cannot presume it. There should be knowledge, right? And so, how do you do that? No? Do you hire a private investigator, go over all of their documents? You can't do that. Okay? You can't do that legally. At some point, I've gone to the extent of looking at the Facebook page of another entity, try and see if there's something there which would show that they actually, let's say, posted something that contained the mark of my client. Right? It's difficult. Proving bad faith can be quite difficult, and so I think that's the problem here. Right? Now you're forced to rebrand. You lose that mark. You're forced to rebrand, and you have sometimes you end up simply with no recourse because you just don't have evidence to prove that it's the other person is in bad faith. They can claim that they just came up with it. This is especially true if the marks are not identical. So let's say they change something. They change a letter, two letters. If it's identical, then the court may say, okay, out of all of the millions of the marks, why did you choose this particular Nike mark, swoosh mark with the word Nike? Clearly, that's in bad faith. Right? That one's clear. But there are many cases where the situation is different. It's not so clear. Right? A good copier or a good infringer is one who does not copy in its entirety. A good infringer is one who actually makes some changes and that allows him or her to infringe, quote unquote, legally. Okay, so that's
Professor,
go ahead.
may I see clarification?
Go
Because it
ahead.
says there must be prior knowledge. Whose knowledge is it? Is it the corporation's knowledge? Because the corporation is an artificial person. How can you prove that? Should it be?
Okay,
Yes,
so
Prof.
the way the adjudicators have decided this is they would look at the board of directors, they look at the officers, and they will try and see if they can. So one common example where there's a clear case of bad faith, Dodi, is in the case of distributors. I have a foreign company. They did not register in the Philippines, but they have a distributor in the Philippines. That distributor decides to do do away with the real owner. So let's say it's paint. They sell paint here. They have a Philippine distributor. They don't have a trademark registration in the Philippines, but they let the distributor sell the product here. The distributor will now, what they'll do is they'll cut ties, or after the distributorship agreement, they'll cut ties totally with the owner, and they will apply for the mark here. Now
Oh,
that's clearly bad faith, right? Because now you can prove that there's knowledge of prior use,
yeah.
maybe even creation or registration of the other party. So those are the more home run, slam dunk cases, right? But it's not always the case. Sometimes it's just another party applying for the mark, even if they don't have any relation with the owner of the mark. Okay, so it's a bit complicated. Questions? Okay. So we have another exemption. No? So the first to file rule, that's a general rule. So it means that generally speaking, in order to become the owner of the mark, you have to be the first person to file it or to register it. However, an exemption if it's the mark or if the mark is applied for in bad faith or fraudulently, in which case your mark is invalid. It's void from the beginning. However, there's another exemption. According to the court and according to our intellectual property code, if you are a mark that's so popular, well known internationally and in the Philippines, it does not matter whether or not you're registered here. You will still be protected because this is by virtue of our law, specifically Section 123.1 E and F, but also under the Paris Convention and also under the TRIPS Agreement. So we also have treaties whereby the Philippines committed to protect well-known marks even if they're not registered. Now, it's not easy. The problem here is it's not easy to be considered as a well-known mark or proving that you are a well-known mark. So there are certain brands that have achieved this status, and by law, by jurisprudence, they are considered as a well-known mark. Harvard University's trademark or logo is one of those. The court said in the case of Fredco Manufacturing versus Harvard University that even if Harvard is not registered here, it's still protected because it's an institution that has global acclaim and it's very much entwined with history. And so they're considered as a well-known mark. McDonald's, in one of the cases, was also regarded as a well-known mark. So what that means is, even if there's no registration here, okay, they're still protected. If someone tries to register McDonald's here, even if assuming McDonald's doesn't have a trademark here, they will fail because the court has considered McDonald's as a well-known mark. But of course, both of these giant brands, no, they have registrations here. Right? So, the law protects those well-known marks that were unable for whatever reason to register their marks in the Philippines, and the law requires combination of these factors to determine if a mark is well known. So the duration, extent, geographical area of any use of the mark, the market share in the Philippines and in other countries, the quality, image, reputation acquired by the mark. So all of these, you need the combination of at least two factors in order to allege successfully that you're a well-known mark. But it's not. It's never easy. In fact, when you argue for a client, let's say the client did not fail to register here, it's very difficult to argue based on a well-known mark. So much so that you'd rather not say it because the examiner will automatically deny your claim and say that you're reaching for the stars, no, when you're saying that your client is a well-known brand, no. So oftentimes you'd rather look for bad faith or try to argue differently, no, because it's very difficult to apply for a well or to be regarded as a well-known mark. Also note that recently, I think just last year or 2 years ago, the Intellectual Property Office of the Philippines started a well-known mark registry. And so you can actually apply for a well-known status. But again, it's difficult and there's a chance of being denied, right? And so not everyone tries to apply for it. Mir, you were raising your hand or no? Okay. Okay, so I'll show you a few marks and let me know if you think that it's registrable. Note that so far what we've discussed is just one ground for denying the registration of a mark, which is that it is confusingly similar with another mark that's filed earlier or registered earlier. But under our intellectual property code, there are many reasons that could be cited why a mark cannot be registered. So, for example, let's try this. Okay. Do you think this is registrable? Why not? Jesus juice. Do you think? Blasphemy. All right. So
Offensive.
you're
Mhm.
which what? Sorry.
It's offensive to the feelings of of the religious
Okay.
religious people.
So you can imagine, no, in a country like ours, I think this mark stands no chance, no, being registered. And in fact, that's what happened. This was denied registration because under our IP code, a mark cannot be registered if it's immoral, deceptive, scandalous, or this is what I mentioned earlier, it disparages or falsely suggests connections with persons, beliefs, or bring them into contempt or disrepute. And so this was denied for the reason that it probably is associated with Jesus Christ. And so the court said it's not registrable. Another mark, sex nightclub XEX under class 41. Registrable? No?
No.
All right. So again, this was denied because it's scandalous, and it's. I guess they found it this immoral.
Offensive to public morality, Prof.
Now, of course, any problem with this provision? 123.1A. What do you think is the problem with the provision, if any? Yeah. Yeah, subjective. Morality can sometimes be subjective. What is considered as immoral now may not be considered so immoral in a number of years, right? Or what's acceptable now. If we have the image of marijuana, for instance, in the logo, it will probably be denied. As in fact, the Intellectual Property Office has denied applications for logos containing marijuana. But when we reach the point, if we do reach it, like California, and legalize it, even for just medicinal purposes, then necessarily that will also change the registrability of the mark. And so, there's a subjective component to it, but I suppose there's merit to why this is in place, right? Because there are certain marks that are just simply, you know, um, disrespectful. I last night, yesterday, I ate from I had delivered cookies. I think it's in Poblacion. Good SH cookies, right? And that led me to the database. I tried searching for whether to see if it's registered. It's not. It made me think, no, will this stand registration, no? Because their packaging is quite it's fancy, it's when you buy a product from them, it's they have this whole box with designs. And so I was wondering, no, well, at some point, no, they might decide to register it, and I'm very curious as to how the intellectual property office will decide on that. Okay, questions. Okay, let's try another one. Okay, anyone familiar with this? Anyone my age or a little bit more mature? So I've had students who are familiar with Harvard Jeans. Or no one wants to admit their familiarity with this brand.
Me,
But
Prof.
it It was out there. Okay, it was out there. It's a real brand. No? So once upon a time, there was Harvard Jeans. But of course, Harvard University filed the case and said that this mark effectively disparages their brand, which they've cultivated for hundreds of years. And so this fell directly under this provision, specifically the one that I highlighted, which is that this mark falsely suggests a connection with an institution or risks bringing them into disrepute. So again, this is the case of Fredco Manufacturing, a landmark case wherein the court cited this provision in order to prevent the registration of Harvard genes. Now, note that the intellectual, we talked about trademark squatting earlier, right? That the fact that because of the first to file rule, you now have entities applying for marks even if it's not theirs. Technically, the Intellectual Property Office of the Philippines can't do anything when a trademark squatter files an application. Why? Because they're not really, they don't have standing to oppose that application. What do I mean? I'm a trademark squatter. I say that I'm the one who created IBL, the IBL logo. The Intellectual Property Office of the Philippines cannot deny it because there's no other registration for that logo. However, what they will do is they will invoke this provision. They will say that it falsely suggests a connection with another institution or another living person. And they will invoke this and they will ask you to execute an affidavit saying that in fact, you are the owner and the creator or the prior user of the IBL logo. So this is one of their ways by which they're trying to tip the balance in favor of the real owner of the mark, even if there is already a first to file rule in our jurisdiction. It's falsely suggesting a connection with persons, institutions. Okay, another one. Okay, Dalai Lama. Right? Allowed. Okay. They're allowed if you're allowed to register it if it's really yours. Right? In fact, I filed this application, right? So I the trust of the Dalai Lama contacted us, asked us to file an application, and so it's allowed. The Intellectual Property Office filed the registrability report, said that that's it falsely suggests a connection with a living person, His Holiness the Dalai Lama, but simply, what we had to do was just to show proof that in fact it's the trust that owns this mark, and so now it's registered, right? So if it so happens that the mark is popular or it's owned by another person, what you'll have to do is to submit proof that in fact they're the ones who are asking for the registration of the mark. So it's this the name of the trust, no? Gaden Forang Trust. Okay. Kush. Allowed?
No,
No?
Kush
No?
is marijuana too, right?
Yeah. Oh, yeah. So Kush is probably marijuana. I agree, Dodi, right? So it's contrary to public order or morality. So again, it's not registrable. However, what about this mark?
May be allowed.
May be allowed. Why?
Because it looks like an acronym, Prof.
Uh-huh. Yeah.
It's an acronym, and so therefore it could suggest something else other than the one above it, which surely refers to weed.
Uh-huh. Okay. So, in fact, there's a registration for the one below, but the one above, I think it's abandoned or disapproved. And the reason is because the brand or the logo below, I think it's from a clothing company, and they probably do have a meaning for each letter. And unlike the one above, there's no clear representation of the marijuana, the plant, and sometimes you can get away with it if you have a clear explanation that disputes the prohibition, that shows that the prohibition is inapplicable to you, then you can sometimes register the mark, as is what happened here. Now, we already discussed this, right? So, brick oven is considered as unregisterable. But what about seamless socks? Is it registrable? Seamless socks. Right, probably not. Right? In fact, I think this is also in the database and it shows that it wasn't registered. And the reason is because it's a description. It's the type of socks that you're selling. And under our code, signs that are generic for the goods or services that they seek to identify, or those that have become customary or usual to designate the goods or services in everyday language, are not considered as registrable. And again, I go back to the case of Ginebra. Right? The court said that even if in Spanish, Ginebra means gin, they still allowed it because according to them, the word Ginebra has attained secondary meaning such that it's now associated with San Miguel's brand. And this also leads me to another hypothetical, which is that of Google. Right? Google has become so famous that arguably at some point it might fall under subsection I. So it's now become something that's customary or usual to designate the goods or services. So if it's being used, let's say or you apply for a service that's, let's say, research, then an examiner might say, this has already become generic. Although I don't think that has happened yet. No? So that's one of the fears, the reported fears of some of the brands. No? But I don't think it has reached that point yet. Okay. Manginasal. Another interesting case. Anyone care to volunteer to recite this case? Very good discussion, Zenit.
In that case, Prof, IFP Manufacturing Corporation filed for registration the trademark of OK hot dog cheese hot dog curl Inasal something,
Mhm.
Prof. And then Mang Inasal Philippines opposed the registration, saying that um because they already registered their Inasal name as logo as well, Prof. So um and they have been using it for the longest time. So the IP IPBLG, I think, Prof. IPOFIL said that there's no violation. And then it was brought to the Supreme Court. The Supreme Court said that there's a violation. They applied the dominance test. They said that the font color, the font size, the background, and the prevalent features of the word inasal is are common between the two marks, to the point that it might confuse potential um, consumers. In fact, it was also stated by the Supreme Court that the consumers might think that the curl, the chichirya, is part of the market of is part of the products of Nang Inasal since it has the same flavor.
Okay, inasal, right? That's that's how important the mark is. Right? When you see this picture, it already evokes a feeling, no, of maybe hunger if you didn't eat earlier. Um, but this case is interesting because we have two marks that are arguably similar with each other. Right? So you have Bang Inasal, you're probably familiar with it. A number of branches, right? Very popular chain. And they have multiple registrations. And then you have OK Hotdog Inasal, which is supposed to be a snack. And they were trying to apply for a trademark. This is the trademark that they were trying to apply for, the OK Hotdog Inasal. And Mang Inasal opposed, saying that that's ours. Why are you're copying us? And so the court here now had to decide whether or not these two marks are confusingly similar to each other. Now, we do know the decision of the case already, but just as a survey, you think they're similar? Yeah? Okay. Yeah. All right. So others would say, sometimes they would say they're not. But let's see. Let's take a deeper look into it. No? So this is the provision again, no, that prohibits the registration of a mark that's confusingly similar to another mark. Note that there is a reference to goods or services, which means that whenever we try to distinguish between marks or try to assess confusing similarity, we have to look not just at the appearance of the marks, we also have to look at the goods or services for which the marks are registered. In this case, you have a mark, one is for a restaurant chain, but the other one is for snacks. So technically speaking, the goods or the services are not identical. But there is a case to be made that in fact they are related to each other. And so we have to look at what the rule is. Now, the reason why we have a confusing similarity rule is because according to the court, according to jurisprudence, what we're trying to avoid is confusion. Confusion in the market. Now, there are two types of confusion. You have confusion of goods and confusion of business. How are those different? Confusion of goods, confusion of business. Anyone? Based on the definition here, how are they different from one another? Go ahead.
Confusion of goods, Prof, is when you mistaken the other for the other. So
Mhm.
two products, you mistakenly thought that this was the product you're trying to buy. And confusion of businesses happens when you've confused the product to be the byproduct of the business, or
Mhm.
by virtue of, so you associate the product with the business.
Okay. So, Shangri-La can say, might argue that they started a wellness company and started the logo that started using the logo that you used earlier, right? That's an argument to be made. It's the case here in Manginasal. It's more of a confusion of business issue. You're not really confusing these two logos. You're not, when you look at OK Hotdog Inasal, you're not confused to buying chicken, an Inasal chicken. In fact, it's different. It's a snack. It's different from the chicken. But arguably, a case can be made that there is a confusion of business. Now you might think that Mang Inasal has entered the domain of foodstuffs or snacks. And so now they're selling these curls that is flavored in asal. Their specialty, a flavor that they're very much akin to, you know, and have technology to do. And so the court said that when you're assessing confusing similarity, this is what you're trying to prevent. You're trying to prevent confusion of goods, confusion of business. Now, again, in order to assess confusing similarity, two conditions must be satisfied. If any of these two conditions is not present, then there's no confusing similarity. One is the prospective mark must nearly resemble or be similar to an earlier mark. You go to the aesthetics, the appearance. Do they look the same? But that's not enough. You also have to satisfy the second condition, which is that they pertain to goods or services that are either identical, similar, or related to the goods or services represented by the earlier mark. So if the OK hotdog inasal was applied for, let's say, a brand of mops, was there confusing similarity? None. Because it's the mark of Mang Inasal refers to food. The other one refers to cleaning equipment. Right? So it's so far from each other. Even if the first condition is satisfied, chances are the second condition is not. And so these two conditions must always be present. Another important thing to remember is that absolute identity of the marks is not required. So again, as I mentioned earlier, those who copy well are those who do not copy in its entirety. They implement certain changes. And the law recognizes that. That's why what the law is trying to prevent is not absolute identity, but merely colorable imitation. And that means the mark denotes such likeness in form, content, etc., that would likely mislead an average buyer in the ordinary course of purchase. So colorable imitation. There's no need for absolute identity. Now, we have two tests that usually govern when assessing similarity. And the court has also flip-flopped on this test. Before, we had what we call the holistic test, which is where what the court will do is they will look at the mark in its entirety. Right? They won't just compare the words. What they'll do is they compare not just the marks but also the labels, the hang tags, basically everything. Every single element in the mark will be considered to assess if in fact it's similar to another mark. The court has abandoned this rule. What we follow now is what is referred to as the dominancy test, which is the rule whereby you look at the similarity of the prevalent features of the competing trademarks. So now you're not looking at all elements. You're looking at the elements that are prevalent, the features that really strike the viewer immediately. And you must compare these elements as they are presented in both marks. Okay, so now let's try and see. So these are the two marks again. So using the dominancy test, the colorable imitation test, as well as the two requisites, no, the court had to make a determination on whether or not these two marks are confusingly similar with each other. And in doing so, the most important element that was considered by the court was what?
Inasal.
Dominancy test, specifically
The inasal word.
the word inasal. Right? The word inasal written in, how is it written? this particular font, right? It's
Same
all
style.
caps, all caps color red or orange in the other mark. Um, and also the spacing is different, right? The positioning of the letters are different. The borders. So the defense of OK Hotdog Inasal is that our mark is different. There are so many other elements that are present there. That's just not in the Mang Inasal mark. Right? And ideally, that could be a very strong argument. Right? The presence of other elements. And you can also argue that the word hot dog can be considered as somewhat, it's also visible, right? Maybe not the most dominant feature, but it's also visible. But the court just couldn't let go of the fact that okay hotdog inasal, the word inasal was copied or appears almost entirely similar to Mang Inasal's inasal word. And so to them, to the court, it's it's baffling, no? Out of all the ways by which you can use the word or write the word inasal, why did you write it this way? Which so happens to really, duplicate sort of Mang Inasal's mark. And so according to the court, here, inasal is the most distinctive and recognizable feature of the mark. So using the dominancy test, they considered the word inasal as the dominant element. And comparing these two, they said they're similar. Now, so again, no? So another, what do you think is the other defense of okay hotdog inasal aside from the fact that there are other elements to their mark?
It is a generic term,
Oh.
actually.
Okay. Anyone from there? What does inasal mean, Candy?
Uh, Roasted chicken.
Roasted chicken.
You roast it inasal.
Okay. So that was the defense of okay hotdog inasal. They said that how is it possible that this other party, regardless of how popular, how many branches they have, they cannot own the word inasal. That's not theirs. It's a term. It's a local term which means roasted or a way of cooking chicken. Alright? And so that was their defense. But the court was not convinced. Because according to them, it's not the fact that you use the word inasal. It's the fact that you use the word inasal as it was written by the prior registrant. So again, they just couldn't let go of the fact that the word inasal was precisely written the same way Mang Inasal wrote it. And so even if there are other observable elements in the mark, such as the word okay, the word cheese, the words cheese hot dog flavor, the image of the block of cheese, it doesn't matter. Because to the court, the dominant element is almost exactly the same as inasal. And okay. Now, the appearance is just one thing, right? Another discussion made by the court was on the similarity of the goods. Right? Because again, they're not really being used or okay hotdog inasal was not applying for the same class. Right? Not even the same set of goods. But according to the court, when you assess the similarity of goods, you will have to look at how they're related to each other. And this is another doctrinal landmark case, the case of Mighty Corporation, whereby the court enumerated factors that are considered whenever assessing similarity. And according to the court, the channels of trade, the purpose of the goods, are these edible products, for instance? The nature of the goods, the business to which these goods belongs, the food industry, those are all factors that we take into account whenever we assess similarity. And in this case, the court decided that to an ordinarily intelligent buyer, it's very easy to be confused. Remember, the ordinarily intelligent buyer, that's always the viewpoint adopted by the court. So they try to place themselves in the position of the ordinarily intelligent person. If that buyer presented with these two options, let's say the ordinarily intelligent buyer goes to um, a, a grocery store, sees okay hotdog inasal, will that buyer be confused into thinking that the mark belongs to Mang Inasal? That's the question. And an ordinarily intelligent buyer is not one that's completely unwary. Right? He's not one that's completely ignorant. He's one that's actually deciphering. He's ordinarily intelligent. He's a purchaser who's used to buying products like this. And so, if that person is presented with this option, will he confuse it with the business of another? And the court said yes. It's very likely that he will be confused because, again, the goods are both food items. So, in conclusion, the court said that the OK Hotdog Inasal mark is not entitled to be registered as it will likely deceive or cause confusion on the part of the public and also likely to infringe the Mang Inasal mark. Okay. Dodi?
Yes, Prof. Just a clarification because I think the Supreme Court highlighted the mark inasal as being was this yeah,
Mm-hmm.
stylized. So, I was just curious if what if the style of the word inasal, the fonts used are different. Or
Mm-hmm.
is different. Would that make a difference, kaya, Prof?
Good question. I would say it would. In fact, OK Hotdog Inasal could refile this trademark using a different font. Maybe their fortune would change. There's a chance.
Might
If
be.
only
I agree.
because
Mm.
the decision is anchored heavily on the fact that the mark was the word inasal was written similarly, and add to that the fact that inasal, even by the court's own pronouncement, is generic or descriptive.
Yes, Prof. Barbecue.
Mm-hmm. All right. So yeah, I think that's one good way um of doing it or approaching it. No, if you're the other party and you lost this case, maybe that's something that you can entertain moving forward. I'm not sure if they did. I'm not privy to the case. All right. Just very quickly, this is the process for applying for trademarks. Um, you're able to do the first part already. But what will happen after you file your applications, if you do decide to do so, is the Intellectual Property Office will conduct a formality examination and substantive examination. They'll do this in one go. So they'll check if your mark is registrable based on the standards that we gave earlier, or if there's anything that's unclear, they'll ask you to clarify it through an office action or a registrability report. If there is none, if there's no issue, they will publish it for opposition. So what will happen is there's a trademark gazette that's being run by the Intellectual Property Office. It will be published there. And for 30 days, it will stay there. That gives the opportunity for brands to actually look at the gazette and see if they notice that you're trying to apply for the mark, then they can file an opposition case. So a trademark opposition case can be filed on the ground of confusing similarity. So this is what Mang Inasal did. They filed an opposition case against a mark that's being applied for. So the big brands, they either have an in-house team that looks at the gazette to to see if in fact there's another brand that's trying to copy them, or they outsource this to the law firms. So the law firms, they look at the marks that are being published, and they will alert their clients whenever there's a mark that's somewhat similar to a mark owned by the client. So it's very important, no? Because once it is not opposed, if it goes through 30 days without anything being filed, then there's an issuance of a trademark registration, a certificate of trademark registration. Now, what if a party was not able to file an opposition case because they simply do not have resources? They do not have someone who checks the gazette. What will happen? Well, they can still file for a trademark cancellation. What's the difference between a trademark cancellation and in opposition? Once a trademark registration is issued, there's a presumption that the owner of the registration is also the owner of the mark. It's a presumption given by the laws, which means that in order to overcome that presumption, you have to present a higher standard of evidence, or a higher amount of evidence to prove that in fact that person is not the owner of the mark. Unlike in an opposition case, there's no registration yet. So if you're trying to oppose, you can oppose, but there's no presumption in favor of the other party that they own the mark. And so the court, in analyzing the documents, the evidence that you have, in analyzing everything, they do not ask for as high a bar as it would be when in fact the mark is already registered. So it's a little bit more difficult. And also, there are standards under the law under which you can file a trademark cancellation. It's also limited. So, Dodi, I'll call on you in a while. I'll just finish this discussion.
Yes, sir.
Very important, if you own a mark, you have to file a declaration of actual use. As AJ mentioned earlier, within 3 years from the filing of the mark, you'll have to file a DAU. What is a DAU? A DAU is any proof that in fact you're using the mark for the goods or services for which you applied or registered it. So let's say you applied for the swoosh mark for Nike under class 25, which is clothes. No, you'll have to prove that in fact you're using the swoosh mark on clothes. So you can take photos of the clothes that are hanging in your stores with the swoosh mark. And that's considered as a declaration of actual use. Now, it's not just the 3-year period. Remember, trademarks, if they're maintained properly, they can be perpetual in nature. Unfortunately, so is maintenance. So you'll have to continue paying as well. So you'll have to pay, aside from submitting evidence of actual use, you'll also have to do it within a year from the 5th anniversary of the registration of your mark, within a year from the 5th anniversary of each renewal, and also within a year from the date of renewal. So that's after 10 years. Within a year after the 10th year of the registration of your mark. If you fail to file any of these, you lose the mark. Even if the Intellectual Property Office does not warn you, they don't give you a notice that you're at risk of losing your mark, that does not matter. You are in charge of monitoring your mark. And there's no leeway, no grace period. If you fail to file a declaration of actual use, it's bye-bye for your mark. And now, the competitors, it's fair game. They can go in and file an application for your mark. So that's another very important thing. And again, this is the cancellation. A trademark cancellation can be filed within 5 years from the date of the registration of the mark. Again, if you weren't able to oppose it, then you have the option of still filing a trademark cancellation case. Now, there are certain grounds for trademark cancellation that do not require the 5-year rule, meaning you can file even after 5 years. And that's when the mark is obtained fraudulently or contrary to the provisions of the Intellectual Property Code. So you can look at this provision. No? Failure to use the mark can also result to a cancellation case. Okay. Very quickly, we already know the definition of patents. It's a novel. In order to be patentable, it must be novel. It must be useful. It must satisfy the inventive step. Right now, for next meeting, another activity that you'll have to do is to conduct a patent search. All right. So just very quickly, no, just for instructions for next meeting, through your learning teams again, no, what I want you to do is to look at the USPTO website. So it gives you instructions on how to conduct a patent search. No, there's also a YouTube video. So I so you won't have to decide, no. So disregard number one. No? I gave so I think this is not the list that I gave, no. I'll send the list to you later. No, I came up with the list earlier, but I was not able to reflect it, no. So it's a different set of list, no, for LT 1, 2, and 3. I will assign it to you. What I want you to do is to conduct a patent search. What to do a patent search, you will have to look at the prior art. What were the similar inventions before they came up with the paper clip that we have now that we know? You would be surprised to see that there were earlier versions of the paper clip. I want you to look into that, discuss how you feel, how you think the prior art has evolved into today's invention, and understand what the claims are being made, what claims are being made in the patent documents. If you watch the video, you should gain an understanding of what claims are. And be ready with the 10-minute presentation. No? So it's not 5 to 6. It's not, so it's, I inputted the wrong slide. No? I fixed it earlier. But it's next week, 5:59 p.m., 10-minute presentation. Shortly, I'll give you the list. I have it with me now. I'll give it to Reg for what particular invention you'll have to look at. Okay? So that's it. Thank you, everyone. Good evening. And Dodi, do you have a question?
Already answered, Prof. Thank you.
Okay. Thank you. Thank you, everyone. Good night.
Thanks, Prof.
Go ahead.
Three questions, Prof. So, the wag kang maingay. Well-known, the registration for a well-known brand, is that per country?
Is it per country?
Or, yeah.
Okay, it is per country. So all members of the Paris Convention are supposed to abide by the well-known mark standard. So all members and most countries are members of it. They'll have their own rules on well-known marks, but you'll have to do it per country.
Even if you're registered as well-known brand here, it could still be registered elsewhere with no problems.
Even if yes, technically. But most countries like ours, we consider the fact that it's considered as a well-known brand in another country in determining whether or not it should also be
They don't
considered.
It's our well-known brand.
Well, yeah, maybe that one. I'm not sure. It depends on the jurisdiction.
Got it, got it.
Okay, these are the topics. Microphone, LT1, kettle, LT2, hair clip, LT3. Okay? So, you will see, you'll be surprised to find that there are so many microphones, so many kettles, so many hair clips. So, choose what you want, choose your preference, and discuss it in class.
Just one that you will discuss?
Just, it doesn't have to be one. Any number which you feel will be able to satisfy the instruction. So if you're, what will best be, demonstrative of your presentation. That's before I used to require each person to find an invention, but you might not have enough time, so just choose the ones that you feel are helpful. Okay. Thank you, everyone. I'll also send this, no? So this is the rubric, which is basically similar to the rubric that we have. So it's the same as the one that we had for trademark search, but it's for a patent search. Okay, thank you.